Hi, I'm Sandra White. There's a lot of information about sales contracts. I used material from the textbook Fundamentals of Business Law Today and the internet to do my research. A few sites that I used include the Encyclopedia Britannica, uslegal.com, and findlaw.com. What is a sales contract? Buying and selling is something that we all do. The definition of a sale is the passing of title, evidence of ownership from one seller to a buyer for a price. When we go to the store and make a purchase for goods and receive our receipt or do financing, this is considered a sales contract. So we all want those nice new things in our home that we can't afford all at one time. So we go out and finance those. We're making an agreement that we are taking the goods with us in return for payment of a monthly amount with penalty if that's not completed. The history of the sales contract, Encyclopedia Britannica states that from perhaps the 13th century on, the English common law dealt with the contractual problems. In the 15th century, the common law courts started to develop a form of action that would render such agreements enforceable. And by the middle of the 16th century, they had done so through the form of action known as assumpsit, which in Latin means he has undertaken. So he's agreed. This is the contract of saying you've agreed and you're making this agreement with somebody else. You're taking on the responsibility. Article 2 of the UCC, the Uniform Commercial Code, applies to the transaction of goods, where Article 2A applies to any transaction regardless of form that creates a lease. A few of the cases that we'll discuss, the first one is Nauticals Insurance Company versus Sharan Investments, LLC. In this case is from the textbook, and this is talking about Balsalini Incorporated was buying a bar from Sharan on a contract. That contract stated you have to make a down payment along with monthly installments. Balsalini purchased insurance from Nautilus Insurance Company. In less than 3 years into the contract, there was a fire damaging personal property at the bar. The Nautilus Insurance Company filed a case against several defendants, including Sharan, to determine who was entitled to the insurance proceeds for the damage. Initially, the courts ruled that Balsalini had failed to consummate the purchase agreement and said that Sharan was the owner of the property. So they're saying the completion of the contract isn't valid yet because they're still making payments on it on a monthly basis. It had only been 3 years since the contract had been in place. So there's still tender due left in the contract. It's just why the courts ruled in favor of Sharan owning the property in the settlement going to him for the damages. Bellini appealed in an appellate court, and they reversed the lower court's ruling that the contract to purchase the property because that contract was in force, it made Balsalini the owner of the property, even though it wasn't completed yet. It was still in force, and it was he was still making his payments, so that put the property in his name. The Cunningham Company versus Driscoll case. This case was from 2005, and two farmers in New York had made a verbal agreement stating that one farmer would purchase his soybeans from the other farmer. He was purchasing roughly 4,000 bushels of soybeans for $5.50 per bushel. At the time, that again was a verbal contract. A couple of days later, the selling farmer had set the buying farmer a contract to sign so that they had it in writing, but the buying farmer never signed and returned that contract. So at the time the season was up and the buying farmer went to purchase the soybeans, The selling farmer didn't have them. He didn't hold them for him because he said, "You never signed a contract. I didn't know we were in an agreement." So the buying farmer took the selling farmer to court, and was trying to sue him for the difference that he had to pay to get the same quantity of soybeans through a different farmer. That was roughly around $9,000 was the lawsuit, because the new bushels of soybeans were about $7.50 per bushel. Anything that is over $500 has to be in a written agreement for the selling contract to be valid. The court said that the buying farmer needed to sign the contract, and the selling farmer does not have to pay the difference that the buying farmer had to pay to get his soybeans elsewhere. Some changes that have been made to the selling contracts since this came into effect. The biggest, most important change that's been made is the adaptation of online environments. So the contracts have had to start working with e-signatures, and not having like valid paper signatures, having to work through email to hold things as a signed contract and stuff like that. Any questions? Thank you and have a great night.